Okay, this is some literary practice for the record. Since 1920, the primary objective of vocational rehabilitation has been to provide rehabilitation services which assist physically and mentally handicapped individuals to become employable. Over the last few years, the poorer and more rural states of this country have made commendable progress in the vocational rehabilitation field. We have for years suspected, and the Social Security Administration Office of Research and Statistics has confirmed, that proportionately more disabled persons live in the South than in any other region of the country. Many of these states have responded to this situation with strong state and local support of rehabilitation efforts. An indication of this support is the fact that many of these states have, for the past 6 years, overmatched their federal rehabilitation funds. Most have organized and are operating cost-effective and highly successful programs. Others are just beginning. I am proud to say that as a result of very hard work and careful organization, South Carolina has, for the past 4 years, operated the most successful rehabilitation program in the nation. Last year, South Carolina rehabilitated 659 per 10,000 disabled persons. South Carolina also led the nation in the percentage of severely disabled citizens who are now working as a result of rehabilitation programs. Commendation of state efforts is not to say that the federal dollar is not important in South Carolina. It is most important. It is absolutely essential. It is my intention only to point out that in South Carolina, the federal dollar is not only needed, it is well spent. South Carolina spends approximately $1,600 to rehabilitate an individual. California spends $6,000 to rehabilitate a similar individual. Now, with the change in formula instituted by Section 105B, we are proposing to take from those who need federal dollars the most and are using this money efficiently and successfully and give these dollars to the states which need it least and which in many cases see far less results from the money they already have. In the last few years, there has been feeling among the more populous and more wealthy states that there should be a change made in the formula for allocating vocational rehabilitation monies. These states do, in fact, receive less per capita in vocational rehabilitation funds. However, the purpose of vocational rehabilitation is not to serve the needs of the general population of this country. The services are designed strictly for physically and mentally handicapped individuals who are potentially employable. The JWK study, commissioned in 1937, stated emphatically that the total resident population is not the best measure of the potentially disabled population. That total population includes large groups that are not or are unlikely to be part of the target population. Now, the very members of this body who were instrumental in seeing that HEW study the formula question are ignoring a very significant part of that analysis. If we fail to amend Section 105B by 1983, almost 1/3 of vocational rehabilitation funds will be allocated to the states strictly on the basis of population. In South Carolina, as in Senator Bumper's state, the money lost in the formula change would not impress persons from the more populous areas of the country. South Carolina will lose approximately $4.6 million. However, to the people of my state, particularly to those handicapped individuals who seek these services, you can be certain that it means a great deal. Over the next 5 years, 18,176 persons who would otherwise receive some type of vocational rehabilitation services will receive none. 3,402 persons who would have become working, productive individuals will remain untrained and unemployed. I urge my colleagues to consider this formula carefully and vote for the Bumpers-Thurmond Amendment. A formula based on general population will do nothing to improve the quality or accessibility of vocational rehabilitation services. Mr. President, in closing, I just want to say that, again, this should be based on the need. I understood when we started this program originally, it was based on need, not on total population. But where the disabled are located, if you want to change it and allow a state the same amount of funds for each individual as being trained under vocational rehabilitation, that would be another thing. But just to base it on population, where you come in with population from New York and California and the big states, they hog most of the money, and they are the richest states in the nation. Is that what we want to do? I do not think so. I do not think that it was the intention of the act. The study that was made showed that the greatest need in vocational rehabilitation programs is where? It shows it was in the South, that there are more disabled people there, and in the smaller states and in the rural states. Are we going to ignore the small states and the rural states and give to the big rich states many more billions of dollars? I hope the Senate will think over this matter as a matter of fairness, as a matter of justice, and apply these funds where they are needed and not just give the money to the states because they are big and have big populations, but apply this money where it is needed. We think the formula was provided in the current law, or certainly under the amendment of the distinguished senator from Arkansas, will be a much fairer and a more just formula than is offered by the distinguished senator from New York. Okay, this will be some jury charge material for the record. Mr. Foreman, ladies and gentlemen of the jury, that is the law on which the indictments in this case are based. Now, with regard to the conspiracy charge, I charge you as follows. The word conspire is defined substantially as follows. If two or more persons agree, acting upon a common purpose, to commit a criminal act, they conspire. A conspiracy is a combination between two or more persons to do an unlawful act or to do a lawful act by criminal or unlawful means. There can be no conspiracy when one individual acts by and for himself only. In order to become a party to a conspiracy, a person must combine with some other person or someone else to effect the object of the conspiracy by means agreed upon. A mere mental purpose cannot justify a conviction of conspiracy. A common design is of the essence of the charge. Now, in order to establish conspiracy, it is necessary first that the conspiracy or agreement to commit the offense alleged in the indictment be established, and second, to prove further that one or more of the parties engaging in the conspiracy have committed some act to effect its object. If the conspiracy is established, proof of the doing of one overt act charged is necessary and sufficient to warrant a verdict of guilty. Now, to constitute conspiracy, it is not necessary that two or more persons should meet and enter into and express a formal agreement for the doing of the unlawful act, or that they should direct it by words or in writing, state between themselves or otherwise what the unlawful object is to be or the details thereof, or the means by which the unlawful combination is to be made effective. It is sufficient that two or more persons in any manner or through any contrivance positively or tacitly come to a mutual understanding to accomplish a common and unlawful design. In other words, when an unlawful end is sought to be effected and two or more persons actuated by the common purpose of accomplishing that end work together in any way to further the unlawful scheme, each of such persons becomes a member of the conspiracy. The success or failure of the conspiracy is immaterial. But before any person can be found guilty of the charge, it must appear beyond a reasonable doubt that a conspiracy was formed as alleged in the indictment, and that the particular person was an active party to it. And under the charges here made, the conspiracy constitutes the offense. It must be made to appear from the evidence beyond a reasonable doubt, before a defendant can be convicted, that he was a party to the conspiracy and unlawful agreement charged, that he continued to be such up to the time that one overt act was committed. The mere fact that the defendant named may have engaged in the performance of any of the acts charged in the indictment as overt acts would not authorize a conviction by reason of that act alone. It is necessary to show that such defendant was party to the conspiracy and the unlawful agreement before his guilt of the offense charged is made out. Each party to a conspiracy must be actuated by an intent to promote the common design. If persons pursue by their acts the same unlawful object, one performing one act and another act, all with a view to the attainment of the object they are pursuing, the conclusion is warranted that they are engaged in a conspiracy to effect that object. Cooperation in some form must be shown. There must be an intentional participation in the transaction with a view and purpose to further the common design. If a person understanding the unlawful character of the transaction encourages, advises, or in any manner with a purpose to forward the enterprise or scheme, assists in its prosecution, he becomes a conspirator. Joint assent and joint participation in the conspiracy may be found, like any other fact, as an inference from facts proven. When a conspiracy is in operation, a person joining in at any time thereafter assumes responsibility for all that was previously done by any party thereto, provided only that the new party had knowledge of the facts that such conspiracy is in operation, and he joins it knowingly. The evidence and proof of the conspiracy may be circumstantial. If this is the case, it is not only necessary that all the circumstances concur to show the existence of the conspiracy, but such circumstantial evidence must be consistent with any other reasonable or rational conclusion. Now, the term overt act as used in these instructions is meant an act committed by one or more of the conspirators. If the evidence shows there in fact was a conspiracy which was intended to and had a tendency to follow the purpose of the conspiracy, such acts may be an agreement between two or more of the conspirators, or it may be an act performed by any one of the conspirators.